Welcome back. In our previous sessions, we've been talking about Article 2 of the Constitution, the executive branch, the presidency, and we're going to continue that conversation for the next couple of sessions. We started talking about numbers that at first you might not notice, but actually contain very interesting stories. The number 4, a presidency is a 4-year term, and at the founding, that was unprecedented. No governor had a 4-year term. Only New York had a 3-year term. But today, 48 of the governors, of the 50 governors, actually have 4-year terms because their governorships have begun to be modeled, have been, in fact, modeled on the American presidency in all sorts of ways. We talked about the number 0. 0 property qualifications in order to be president, unlike property qualifications that existed for most governorships, all the governorships really, at the time the Constitution was adopted. No governorships today. And when you think about the fact that the Constitution creates a strong presidency open to low-born persons, it's pretty remarkable when you remember that in England, the chief of the head of state is anything but low-born. He's a monarch, to the throne born. But in America, folks born in very modest circumstances have become president because of that invisible number, what's not there, property qualification, 0. Andrew Jackson, low-born. Ulysses S. Grant, Harry Truman, Ronald Reagan, Gerald Ford, Bill Clinton, Barack Obama. Now, some of these folks had acquired some modest fortunes by the time they became presidency, but not all of them. Not, for example, Bill Clinton or Barack Obama or others. So that's pretty extraordinary. Think about another 0. 0 religious qualifications in order to be president. Again, something that's not there. When we look at the terse text, the written Constitution, we want to focus on what's there and what's not there. No religious qualifications to be president, whereas almost every state governorship, except for Virginia, had a religious test. 2 of the 4 folks up there on Mount Rushmore, Jefferson and Lincoln, not members of, not churchgoers in organized denominational sects at the time of their elections. So 2 of the 4 are kind of not conventional churchgoers. 2 of the 4 presidents up there on Mount Rushmore. Think about the last presidential election. The Constitution was created by a group of largely white Protestants, mainstream Protestants. Of the 4 people running for the presidency and the vice presidency last time around, Mitt Romney is a white Protestant, but a member of a denomination that didn't even exist at the founding, Mormonism, a kind of a new denomination. Paul Ryan and Joe Biden, both Catholics. The only mainstream Protestant, Barack Obama, non-white, father a Muslim from Africa. And so dramatic possibilities, democratic possibilities, egalitarian possibilities, simply from what's not in the Constitution, the 0, the no religious qualifications. We talked about another number that really is in the Constitution, if you look carefully, in the executive branch. In Article 2, if you look carefully, 3/5. The 3/5 clause was built into not just the apportionment of the House of Representatives, but also the structure of the Electoral College. And that's going to give, actually, southern slaveholding states a big leg up in the presidential sweepstakes, because they're going to be able to count their slaves for extra electoral votes. Remember, an anti-slavery rule wouldn't have been, 1, count slaves just like everyone else, equality. No, the question wasn't, whether slaves were going to vote. Of course they weren't going to vote. The question is how much extra clout slave states were going to get in the House of Representatives, the Electoral College, because of the existence of slavery. And 3/5 basically meant they were going to get extra clout. So the number 0, the number 3/5, the number 4. I want to remind you of one other number that we talked about, the number 1. There's one president at any given time. It's a very personal office, a very lonely office, a singular office. And it's always in session, 24/7. 7, 365. Some more numbers. Now you might think, well, what about the vice presidency? Is the president really as lonely as you just said, Professor? Remember that at the founding, under Article 2, actually presidents and vice presidents don't run as teams, as tickets. Under the original Article 2 of the Constitution, the person who is vice president is simply the person who comes in second in the presidential sweepstakes. George Washington won the presidency, and John Adams came in second in the presidential contest, both in 1789 and then again in the re-election process. So the idea of a president and vice president sort of teaming up as being part of a ticket is going to emerge a little bit later on as political parties come onto the scene and are blessed by a modification of Article 2, the 12th Amendment. And we're going to talk about that in later lectures, so stay tuned. But for now, just recognize that presidents and vice presidents at the founding aren't necessarily teammates working together intimately. George Washington actually didn't rely very much on John Adams in his administration, but the very existence of the vice presidency does confirm this idea of 24/7, 365. The presidency is always in session. You always have to have a president. There are many months of the year that Congress isn't in session. Courts may go out of session, but you always have to have a president because executive power is continuous and seamless. The presidency never sleeps. And that's why the nanosecond that one president dies or resigns, the vice president, the understudy, seamlessly comes in to fill the breach. That's not true in the House of Representatives, for example. If a representative resigns or dies, we have to wait for a new election. In the Senate, if a senator dies or resigns, the governor can pick a replacement, but that's going to take some time. And the rules changed a little bit after the 17th Amendment. We'll talk about that in later lectures. And by the way, why the governor? Because in states, the governor was going to be continuously in office, and the state legislature might be in session or might not be in session. So even at the state level, this idea of executive power being continuous was kind of built into the Constitution if you read very carefully. So the importance of an executive understudy, of a number two, who can at any instant just step up and fill a breach created by a presidential death or resignation. It's an important element of the nature of executive power, American style, the seamlessness, the continuity of executive power. Now, the Constitution, Article 2, also provides, because it's so important to have a president at every moment, the Constitution also provides that if both the president and the vice president are somehow out of action, dead or disabled, have left office in a resignation, that Congress, by law, can provide for a line of succession. Now, today, the Speaker of the House is under a statute that's been passed in the 1940s, next after the vice presidency and the president pro tem of the Senate after the Speaker. But not at all clear that that's actually what the Constitution contemplated. The Constitution says that the Congress is supposed to designate an officer to succeed a vacant presidency, vice presidency, and it's not at all clear that members of the legislature are officers in the relevant constitutional sense. At least that's what James Madison argued way back in the 1790s when Congress passed the first succession statute. That first succession statute put legislative leaders, Senate leaders and House leaders in the line of succession. And Madison said, no, no, no. Officers, by officers we meant cabinet officers, folks in effect who have been handpicked by the president to succeed him, not legislative leaders. And in fact, there's another provision of the Constitution that says that lawmakers, legislators, cannot be executive officers. In England, in a parliamentary system, you've got members of parliament who are also part of the cabinet. You've got a prime minister, the head of the executive branch, who is also a sitting member of parliament. But the Constitution, in Article 1, actually says senators and representatives can't be officers. So the minute, for example, Senator Hillary Clinton is asked to become Secretary of State Hillary Clinton, she has to leave the Senate. Senator Salazar is asked to become Cabinet Secretary Salazar. Senator Kerry is asked to become Cabinet Secretary Kerry. These folks have to leave the Senate because of a thing called the incompatibility clause in the Constitution. You can't, in America, this is a feature of American-style separation of powers, be a member of both the legislature and the executive branch. And so Madison said, now listen, how's this going to work? You can't simultaneously be Speaker of the House and President at both ends of Pennsylvania Avenue, signing bills and then deciding as Speaker of the House and then deciding whether to veto them or not as President. So it doesn't really make sense, Madison argued, for sitting lawmakers to be your caretaker presidents. And if they have to step down from the legislature in order to be president, Madison said, well then, why not actually have cabinet officers do that? Because they would be part of the administration, handpicked by the persons who had actually vacated the office. Again, this idea of executive power as very individualistic. We vote for a person as president, and if that person can't be president, why not have someone that person has handpicked, their Secretary of State, for example, carry on their mandate. In a world of political parties, Madison's ideas, I think, actually become even more powerful, because if you vote for Republicans as George W. Bush and Dick Cheney, you shouldn't end up, if disaster strikes, with a Democrat, Nancy Pelosi. If you vote for Ronald Reagan and George H.W. Bush, you shouldn't end up with Tip O'Neill. If you vote for Barack Obama and Joe Biden, you shouldn't ever end up with John Boehner. So we're going to come back to that in later lectures. But for now, the very existence of a vice presidency confirms the unitary and continuous nature of executive power, and so does the provision for succession in the event of double death or double disability. Now, the unique personal nature of executive power is also there if we look carefully at some other words in Article 2 specifying the presidential oath of office. There's not that much in the Constitution about the presidency, and yet, word for word, the framers of the Constitution specified the presidential oath. That's a signal that they took oaths very seriously, and they wanted us to get a clear picture of what the presidency is all about. I do solemnly swear that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. Okay? Now, I do solemnly swear. The Constitution begins, we do, and now here we see actually the singular, I do solemnly swear. It's a very personal office. I do solemnly swear that I will, to the best of my ability. It's a very personal office. And let's take those words and again try to look at what's there and not there, understand them in context. What's not there? I don't have to swear any religious test. Some presidents have chosen to add the words, "So help me God," after the constitutionally prescribed oath of office. Almost all the presidents in the 20th century have done so, and the 21st century. But those words aren't in the Constitution. They're a personal choice that a person can add or not add. Now, in the state constitutions, there actually were religious oaths that needed to be sworn by people before they could become governor. In England, you had to, the coronation oath required the monarch to swear to be defender of the faith. The oath had to be administered by an Anglican bishop or archbishop. Not so in the presidential oath. Doesn't specify any religious trappings. You can use a Bible if you want, but you don't have to. In England, you had to use a Bible for the monarch's coronation oath, and not just any Bible. It had to be a Protestant Bible, basically the King James Bible, not the Douay Catholic Bible. So England had all sorts of religious elements to its oath of office, but for the monarchy, but not for America's presidency, sort of a secular office. And what do you swear or affirm? Actually, you don't even have to swear. If you have a religious objection to swearing oaths, you can affirm. I do affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. You're not defender of the faith. You're not even a defender of each and every statute that Congress passes. You are a defender of the Constitution. Now, what does that mean? In England, after the Glorious Revolution of 1688-89, when kings were supposed to be limited, so that they wouldn't just rule by executive fiat, because no one had elected them. In England, monarchs pledged to follow parliamentary laws. The emergence after the Glorious Revolution of parliamentary sovereignty, and the executive branch pledged to enforce every parliamentary statute. The presidential oath doesn't quite read that way. It says, I will defend the Constitution. And maybe statutes that have been passed by the legislature might be unconstitutional. And then what's an oath-bound president to do? And I think if we read the oath carefully, the president is supposed to defend the Constitution even at the expense of a statute, because in America there's the idea that the statutes might be unconstitutional, because the Constitution comes from the people themselves, and the legislature, the Congress, is just one branch of government under the Constitution. That's not how it works in England. In England, Parliament itself is sovereign. It's the highest body. It's, in effect, the British people. And anything that it enacts is the highest law. And there's nothing quite higher than an act of Parliament, at least in the British constitutional understanding at the time of the framing. So when Parliament passes a law, that's the highest law of the land, and monarchs are supposed to unwaveringly enforce that, no matter what, even if the law, for example, violates religious rights or suppresses free speech or does other things. Monarchs are supposed to enforce, in England, the laws of Parliament. But in America, the president's supposed to defend the Constitution, and if the legislature has violated the Constitution by passing a statute that suppresses free speech or goes beyond Congress's enumerated powers or takes property without just compensation after the adoption of a Bill of Rights or deprives people of jury trial or the like, the president is supposed to defend the Constitution and not the statute. So an important difference. And how might a president do that? One easy and obvious way from the beginning is to veto a bill that is presented to him if he thinks it's unconstitutional. So even if the House thinks the law is constitutional, and even if the Senate thinks the law is constitutional, a bill is constitutional, that doesn't end the thing. The president should simply say no and veto the bill. So measuring constitutionality in the American system is not simply and only the province of judges. It's diffused more broadly. If the House thinks it's unconstitutional, they should just vote no. If the Senate thinks it's unconstitutional, they should just vote no, and they can prevent the thing from even becoming a law. But if they both pass it, the president can veto it, and indeed, early presidents used their veto pens overwhelmingly in constitutional situations. Of the first 50 vetoes, let's say, roughly, in the pre-Civil War period, half of them were constitutionally based vetoes. Vetoes where the president sent a veto message saying, I think this bill is not merely bad policy, but is affirmatively unconstitutional. So about, say, 24 of the 50 early vetoes of the president are constitutional vetoes based on the president's constitutional oath of office to defend, preserve, protect, and defend the Constitution of the United States. By contrast, in that entire period before the Civil War, basically the Supreme Court has invalidated, well, let's say even before 1850, they've invalidated one statute using a thing called judicial review that we'll talk about in later lectures. So it's a case, 1803, Marbury versus Madison. So one judicial invalidation, 24 presidential vetoes based on constitutional objections. And many of these vetoes are vetoing laws that courts have upheld already or would uphold. We'll talk about that a little bit more in our next lecture when I actually tell you a little bit about the next picture that I want you to focus on, which is a picture of Andrew Jackson. All about, actually, this picture is going to be all about his veto power and his relationship to the Supreme Court. But in early America, in the early constitutional experience, presidents are defenders of the Constitution every bit as much as courts, arguably more so. In our next session, we're going to talk about some other presidential powers that intersect with and reinforce the veto power that we've just been talking about. And I'm going to walk you through the next picture in our series. Remember, every chapter of the book, America's Constitution, a biography, has a picture. That picture tells a story. We talked about Washington's picture, the picture of the Washington family in our previous lectures, and in the next one we're going to talk about the picture of Andrew Jackson. And if you understand that picture, you will understand the antebellum presidency. See you then. Welcome back. We're in the middle of a conversation about Article 2 of the Constitution, the executive article, the article centered on the United States presidency. We've already begun to talk about one of the most important powers of the presidency, the veto power. And that power is actually textually in Article 1 of the Constitution, which talks about how laws are to be made. It's an extraordinary power because, in effect, the president is almost a third branch of the legislature. So a law has to get the approval not just of the House and the Senate, but as a practical matter, the president too. Now, it's true that a presidential veto can be overridden by a 2/3 vote of each House of Congress, but that's a very hard thing to do. It's an especially hard thing to do once political parties emerge on the scene, because usually the president's party will have at least a third plus one in a single House. And indeed, as we'll see later on, it's not until after the Civil War that any presidential veto of any significance is actually overridden by Congress. Now, to give the president a sufficient sort of fortitude to use that veto power, and remember, this veto power that makes the president far more powerful than virtually every state governor in 1788. Only the Massachusetts governor has a veto pen comparable to the president's veto pen, whereas today, all the governors have veto pens. Some of them can be overridden with less than 2/3, but all the governors look more like presidents now than was true at the founding. The governorships have been basically reinvented in the image of the presidency. Now, to bolster this veto power, the Constitution gives a president a 4-year term, so he has a while to make his, if he vetoes bills early on, to make his case before the American people, before he has to return to them for re-election. He also has a constitutionally guaranteed salary. Congress can't augment the salary if they like what he's doing and want to basically sort of bribe him to sign more laws, and they can't diminish his salary, so sort of punish him for exercising that veto power. He has more salary independence from the legislature than even the judiciary salary, and we'll talk about the judiciary in the next couple of sessions. The judiciary salary can't be diminished, but it can be increased. And the reason is judges are going to serve for a very long time, maybe for life. There's going to be inflation, and so you might need to increase their salaries, whereas presidency is a 4-year term, and within that 4-year term, inflation probably won't be so bad. So in order to bolster the president's constitutional independence from Congress, his salary can't be increased or decreased. It gives him a sort of a base on which to stand. So note here we see sort of the idea of of separation of powers, of checks and balances, of the idea of the president as independent of Congress, trying to counterbalance Congress, keep Congress from doing unwise or unconstitutional things. Remember, the veto power is especially to be used if the president thinks that Congress has acted not just unwisely, but unconstitutionally. Fully half the vetoes before the Civil War were really constitutional vetoes. Today, one doesn't see that nearly as much in the presidency. Today, courts do a lot more constitutional stuff. Maybe presidents do a lot less. But at the founding, this idea of salary independence strongly interacted with the veto power. And while we're talking about salary, let's just pause for a moment just to recall that we pay our presidents in America. That's provided for in the Constitution. This is a democratic idea, an egalitarian idea, because if you didn't pay the chief executive, then only people who were fabulously wealthy could afford to serve. So along with the payment of the constitutionally provided for compensation for members of the House and the Senate, the compensation structure provided for the presidency is a deeply egalitarian one. George Washington at the beginning actually said, oh, no, you don't need to pay me. You know, I can handle it. And Congress insisted that he be paid and that he accept the payment in order to establish this tradition, a Republican tradition, a democratic tradition, opening the presidency to talent of all sorts. And as we've seen, there are no property qualifications, there are no religious qualifications. It's really quite striking. And the qualifications that do exist, like that a president be natural born and 35 years old, actually have an egalitarian structure to them. The presidency was especially hard for the framers to figure out because they wanted an office much more powerful than the existing governors, who weren't really able to keep state legislatures in sufficient check, except maybe in Massachusetts and maybe in New York, thought the framers. They want a presidency more powerful than state governors, but they don't want to create someone so powerful as to be the kind of tyrant, king, against whom they've just successfully waged a military revolution, led by George Washington, of course. So it needs to be bigger than a governor, but not so powerful as a king. But there's a vast difference between those two. How do you sort of specify the powers for this new office, especially because presidents do so many different things. And it's maybe hard to identify all the things that they might need to do. And so Article 2 actually begins in a very interesting way. It says the executive power shall be vested in a president. And the question is, and then it goes on to enumerate, to list some of the powers that a president would have, some of the executive powers, but is that a comprehensive list? That's the question. In Article 1 begins, all legislative powers herein granted are vested in a Congress. So it itemizes, Article 1 does, all the congressional powers. So congressional power either has to be very explicit in Article 1 or implied in those enumerations, sort of following from the basic structure and spirit, the spirit as well as the letter of those enumerations. But Article 2 has been construed to give a president a residuum of executive power from that very first sentence. All executive power is vested in the president, above and beyond the items on the list. Where, for example, does it say explicitly that a president can fire cabinet officers at will? Well, it doesn't, but early on, and we'll talk about this more in later sessions, but early on, the view basically prevailed that a president needs to be able to monitor his executive subordinates. He needs to wage foreign policy, so if he loses confidence in his Secretary of State, he's got to be able to fire him or her at will. He's Commander-in-Chief of the Army. If he doesn't like the Secretary of Defense, earlier called the Secretary of War, he's got to be able to fire that person at will. That's just the nature of executive power. It flows from the vesting clause of Article 2, that executive power is vested in the president, and that power includes the power to oversee your cabinet officers, your lieutenants. Where does it say in the Constitution explicitly that presidents can negotiate treaties? It doesn't, secretly even, doesn't quite say that, but that's part of executive power. Where does a president get the ability to repel an invasion? If some other nation attacks, to sort of resist. again, I think it follows from the basic nature of executive power. Lincoln suspends the writ of habeas corpus. And critics say, where do you get that authority? It doesn't say so explicitly in Article 2. And actually, the power to suspend habeas corpus is mentioned in Article 1, and that's actually the legislature. So how can you as president do that? Even kings of England can't do that. And here's what Lincoln says in response. You got to understand that the presidency is always in session, 24/7, 365. Attacks may arise, insurrections and rebellions, when Congress isn't even in session. And indeed, the assault on Fort Sumter has occurred when Congress isn't in session. If I don't act immediately, and I'm the only one basically in office 24/7, 365, there may be no Constitution to come back to when Congress finally comes back to town. So I have to act immediately in order to keep the constitutional system afloat. I've called Congress into session as soon as possible. I've actually accelerated their first meeting, and I get to do that because, again, as the person sort of always on duty, I have to sort of monitor the situation. I've called them back into session. When they come into session, they're going to need to approve what I've done. But in the meantime, I, vested as I am with the executive power of the United States, above and beyond all the specifically listed presidential powers, have to have the authority to keep the United States going, keep the Constitution going, to preserve, protect, and defend the Constitution as an ongoing project. Jefferson earlier took a kind of similar position. Congress and the Senate hadn't authorized him to negotiate with Napoleon for Louisiana, and when Napoleon signals that he might be willing to sell the entire territory to the United States, Congress isn't in session. But Jefferson seizes the opportunity. This is a chance to secure the borders of the United States, to absolutely create a strong independent America that will be able to survive against European monarchies, to basically get the Spanish and the French largely out of the New World, as well as having expelled the British, at least from the original colonies and states. So when that opportunity arises, Jefferson, who's the only one in there, 24/7, 365, seizes the chance. And the best textual defense of these unilateral exercises of executive power by the likes of George Washington and Thomas Jefferson and Abe Lincoln, negotiating treaties even without, secretly sometimes without Senate pre-authorization, acquiring Louisiana, suspending the writ of habeas corpus, is that the executive power is vested in one person who's continuously in office. That person can do a whole bunch of things to keep the United States afloat. And here's the key. Afterwards, Congress is going to need to approve a whole bunch of these temporary unilateral measures. Any treaty that Washington negotiates is going to have to be confirmed by the Senate. The Louisiana Purchase actually was confirmed by the Senate, and then the House is going to have to agree to pass a law to pay Napoleon the price for the land. So Lincoln suspends the writ of habeas corpus, but calls Congress into session, and Congress approves what Lincoln has done when he was the only one in town holding down the fort. So the nature of executive power is that it's continuous, one person always in charge, and he's in charge of basically preserving, protecting, and defending the project. And we don't want him to be a king, but he's way more than a governor, and we see that when we look at some of the specific powers. President, for example, is commander-in-chief, and that's way more power of the army and of the militia when it's in actual service, and that's way more powerful than any governor. You know, he controls continental professional troops, but he doesn't control the militia at all times. States actually control militias, and there's a kind of check against a possible arbitrary military coup d'etat, tyrannical takeover. So that's unlike England, where the king is basically the head of all the armed forces at all times. So more than a governor, less than a king. The king can pardon anyone, anytime, even after an impeachment. A president can pardon only for federal offenses, not state offenses, and can't spare someone a punishment of the sanction of an impeachment court. So less than a king, but way more powerful than most governors who didn't have comparably sweeping unilateral pardon power. Why does a president need the power unilaterally at any moment to pardon someone even before a crime has a criminal has been indicted or convicted? A president can issue a pardon pre-conviction, pre-trial, pre-indictment. At any moment after the crime has occurred, the president can simply say, I pardon you. Way more powerful than a governor. Why? Well, in part for national security reasons. And again, this idea of 24/7, 365. Suppose there's an insurrection somewhere, and Congress might not even be in session. But if the president has the ability at any moment to say to the rebels, lay down your arms and I will spare you. I will be merciful. I will not prosecute you. He might have that, and he's maybe, again, the only one in town when the insurrection breaks out. That unilateral power to pardon at any time connects to our larger stories about national security and the continuity of executive power. So a president who's way more powerful than a governor, but less powerful than a king. Kings can negotiate treaties, or kings of England used to be able to negotiate treaties at will and implement and ordain them. Maybe if money was required to implement them, Parliament might not need to get involved, but not necessarily for all treaties. Presidents can negotiate treaties unilaterally, but the Senate is going to have to give its advice and consent under the Constitution. So less powerful than a king, but obviously more powerful than governors who aren't involved in a treaty-making process. Presidents are going to be able to pick their cabinet officers. That wasn't true in most states. The upper council, the governor's council, was often not picked by the governor, but by the legislature or by other forces. But presidents are going to be able to pick their cabinet officers, their advisors. But again, the Senate is going to have to confirm those officials, advice and consent. So presidents aren't going to be able just to pick their sons-in-law or something, their incompetent sons-in-law. There's going to be a check, the Senate checking this power. So more powerful than a governor, but way less powerful than kings who were able to create offices at will and fill them. The king was the font of all honor in England and the embodiment of Britain internationally, so could unilaterally ordain treaties and create offices. The president has less power than that, but way more than a governorship. Perhaps the biggest related feature of the various powers of the presidency are that he's a person who doesn't just implement laws one by one, but all of them all together. He is supposed to give reports on the state of the union and recommendations to Congress. He's a generalist. He has to sort of see how all the laws are working together, and this is another argument that Lincoln makes. Listen, if there may be certain statutes and certain court orders, but if I enforce them, maybe as a practical matter, the other laws and other constitutional provisions won't be enforced. So you have to give me some leeway to try to basically make the whole project, the constitutional project as a whole, work. Well, that's a very dangerous and powerful office. And I've just defended the idea that presidents can do things that even kings of England were not allowed to do, namely suspend the writ of habeas corpus temporarily until Congress could be called back into session. So why would we ever give a president more power than a king? And the answer is because we have two important checks on the presidency. First, election. Kings of England can be idiots, can be tyrants. They're born and you're stuck with them. We pick our presidents and we pick them very carefully. There's a vetting process, and so up front, ex ante, we have a lot of checks to make sure that this person who wields awesome power is going to be someone we have a lot of confidence in. We've created a very elaborate and democratic system of presidential selection. And we have some, and here's one of the biggest checks and balances. Not true for the British monarchy. If they misbehave, there's always impeachment. Kings of England couldn't be impeached in the case of misbehavior. So what do you do when you have a tyrant king? Well, in England, sometimes you basically had to behead him, Charles I, which led to the English Civil War in the 1640s, or chase him off the throne and force him into exile, as occurred in the Glorious Revolution with James II. So, but in America, we have a much more democratic and peaceful system. You don't have to behead the person. You don't have to sort of force them into exile. You can just remove them peacefully from power. Do it democratically with the House and the Senate, and limit the punishment. It's not going to be a criminal process. The punishment in cases of impeachment will be limited to removal from office and possibly disqualification from holding future office. It's a democratic system. It's a limited system, and it's going to prevent, and so it doesn't lead to necessarily automatically criminal sanctions. And we specify a standard: high crimes and misdemeanors. Now that's a little bit of a fuzzy standard, but we create a democratic system to implement it: the House of Representatives and the Senate of the United States. We're going to talk more about impeachment in future sessions. One little feature interesting to note about presidential impeachment, and president isn't the only person who's impeachable, so are cabinet officers and judges, but when a president is impeached, that is indicted in effect by the House to be tried in the Senate, the person who presides constitutionally is the Chief Justice. Why? Because otherwise, who would be the ordinary presiding officer of the Senate? Constitution says it's the vice president, and you don't want the vice president basically presiding over a trial that could, if it results in a conviction, make him president. He would have too much at stake, so that wouldn't be fair, that wouldn't be impartial. So when presidents are impeached, chief justices preside precisely because vice presidents shouldn't. Which raises the interesting question: who should preside when the vice president is impeached? The Constitution doesn't say explicitly, and if you just read its words literally, perhaps an argument can be made, well, that he gets to preside. He's the presiding officer of the Senate. But can that be right? In later lectures, I'm going to argue that that can't be right, that we have to read not just the Constitution's written text, but its unwritten spirit. So stay tuned on that. We will come back to the fascinating little wrinkle of vice presidential impeachment. But before we go, I promised to tell you a little bit about the picture that's associated with this chapter of the book. It's a chapter of the book. The book is America's Constitution, a Biography. It's been our guidebook throughout this part of the course, and you don't have to read it, but if you do, you'll get a lot more details than I'm able to summarize here. Chapter 5 is entitled Presidential Powers, and that's what we've been talking about for the last couple of sessions. Remember our last chapter, we had George Washington's picture up there. This is a picture of Andrew Jackson. And if you understand this picture, you understand a lot of the themes so far. This is a picture that says King Andrew I. See, because the critics of Andrew Jackson are saying he's acting like a king. That's the anxiety. Our president's going to become like kings. And so they've got him with a crown and a scepter and a mace and a royal gown. And so his critics say he's acting like a king. And what do the critics call themselves? They call themselves the Whig Party, choosing a name for the anti-monarchical party in England. Now, the Whig Party no longer exists, but they pick a name basically says Andrew Jackson's acting like a king, and we're resisting that. So he's presented as a king-like person, but and in one hand he's holding the veto. That's a big power that he's got, his mace. And why are they objecting? And he's trampling the Constitution underfoot, according to his critics, and stepping on a judicial book. And so what are the critics complaining about? They complain about the fact that Andrew Jackson has vetoed bills that John Marshall has upheld, like the bank bill. Marshall in McCulloch versus Maryland said the bank is constitutional, but when the bank came up for reauthorization, Jackson said, I don't think it's constitutional, and I have to defend the Constitution. I've taken my own oath, and so if I don't think it's constitutional, I'm not going to sign it. So very much the vision that we've been talking about, the presidents using their veto power, maybe their most important power, making them almost 1/3 of the legislative process, using that power to implement their view of the Constitution. And critics saying, oh, you're acting too much like a president, like a king. But let's note a few final features of Andrew Jackson. You know, if he's a king, he's an odd one. He was very low born, didn't come from any sort of wealthy family, and that captures the idea of a presidency open to talent. A few other things about Jackson. He is the dominant political figure in antebellum America. America's Constitution, which begins with Washington, will culminate in Tocqueville's America, which is basically Jackson's America. That's the dominant system before the Civil War. And the features that we've been talking about are well captured in the person of Andrew Jackson. He is, we're saying the Constitution is democratic and open to people of all talent, at least free white people, and he is low born. So it's a democratic Constitution. And he helps refound the Democratic Party. They claim that they're proud Democrats. But the Constitution is also pro-slavery, and Andrew Jackson is pro-slavery. The Democratic Party is the pro-slavery party. That's because of 3/5. 3/5 is going to basically empower the South, make slaveholders like Andy Jackson have the inside track for the presidency. So the Constitution is pro-democratic and pro-slavery, and so is Andrew Jackson, and it's all about national security. Who is Andrew Jackson? He's a guy who can beat the British just like George Washington. He beat them at the Battle of New Orleans in the War of 1812, which is the American Revolution, sort of, you know, part 2. So your early presidents, remember, they're all basically leading diplomats and or battlefield generals. So America's antebellum Constitution is, I think, very much nicely embodied in the person of Andrew Jackson. Democratic, slavocratic, a powerful protector of national security. So much for the presidency, at least for now. In our next couple of lectures, we'll talk about Article 3 of the Constitution, the judiciary. Hope to see you then. Welcome back. Today we're going to begin a discussion of Article 3 of the Constitution, the judiciary article. The discussion that we're going to have in this session and the next one corresponds to Chapter 6 of the book, America's Constitution, a biography. The chapter is called Judges and Juries, and it opens with a picture of the famous John Marshall, the great John Marshall, perhaps the greatest Chief Justice in the history of the United States. And in the next session, I'll tell you a little bit about this picture and how it sums up many of the themes of this segment, this chapter, Judges and Juries, many of the themes of Article 3. But before we get to that, you may be wondering why there's only one chapter on the judiciary. Remember that after our chapter on the preamble, the first couple of lectures of this part of the course, we had actually 2 chapters on Article 1, the legislature, so 4 lectures on that. We had 2 chapters, again, 4 lectures on Article 2, the presidency, but we've only got 1 chapter on the judges. And in fact, actually, they have to share that chapter with the juries, as indeed in Article 3, judges share pride of place with juries. So what's up with that? Why less attention to the judiciary in this walk through the written Constitution? And the answer is because there's less attention in the written Constitution itself to judges. It's Article 3 out of 3. And in fact, there's less text in Article 3. It's the shortest article of the 3 big ones. The legislature gets the most attention. It's first and longest. The executive is second and second longest. And as I said, the judiciary is third out of 3. And the federal judges who feature prominently in Article 3 actually have to share the stage with juries who can be seen, as we're going to talk about a little bit more, as the lower house in a sense of a bicameral judiciary. So just as there's a bicameral legislature with an upper house, a Senate, and a lower house, the House of Representatives, are kind of a bicameral judiciary. with the upper house of judges selected in more refined ways, a small group of rather elite folk, and the lower house, a more populist house, corresponding perhaps to the House of Representatives, the lower house of the framers' judiciary, at least, of the original Constitution's judiciary, involves juries. So one question really to begin with is, why did the Constitution, why did the framers treat the judiciary least and last? Why did they make them third out of three? And I think the answer begins with the American Revolution. You can't understand our Constitution without understanding our history. Our history as a people is, to a very considerable extent, the history of our wars, and the Constitution is a reflection of our wars. The original Constitution is a reflection of the American Revolution. As we're going to see, after the Civil War, the Constitution is going to be transformed with three important amendments, the 13th, 14th, and 15th Amendments. And in the 20th century, actually, wars, both World War I and World War II and the Cold War, will be reflected in the written text. So here's the key fact you need to understand about Articles 1 and 2 and how they were affected by the American Revolution, and then we'll come to Article 3. Article 1, big idea. This is going to be, Congress is going to have the power to tax and regulate, and precisely because of that, this new Congress under Article 1 is going to have to be much more representative than the old Congress under the Articles of Confederation. The old Congress couldn't tax individuals, couldn't pass laws as such directly regulating individuals, and so it didn't need to be picked by individuals. But since the new Congress is going to be able to tax individuals, is going to be able to regulate individuals, it has to be representative of individuals. Why? Because that's what the American Revolution was all about. No taxation without representation. Parliament had the pretension to purport to try to tax and regulate Americans, even though Americans didn't vote for Parliament. That was illegitimate. That was one of the basic rallying cries of the American Revolution. These guys whom we're not voting for shouldn't get to directly regulate our internal affairs and shouldn't get to tax us. That's the American position as of 1776. So that's what the Revolution is all about, and you see the reflection of that in Article 1. Now, the Declaration of Independence is also declaring independence from the king. George III was viewed by Americans as a tyrant, a despot, and Article 2 is a reflection of how we don't want our president to be like England's king. We don't want our George Washington, to look like England's George III. And so we try to structure a presidency that has some of the virtues of the English monarchy, stability at its best, the English monarchy at its best, stability in foreign affairs, a strong military leadership and commitment to national security, but with all sorts of democratic safeguards of election and impeachment and checks and balances and the like. So Article 1 reflects the American Revolution. Congress has to be representative. Article 2 reflects the American Revolution. We want a president who's very strong, like a king, but isn't going to be tyrannical, like a king, isn't going to be possibly an idiot or stupid, like a king can be, because in England you're just born to the position, and maybe you're just really not, frankly, equipped to govern, but there you have it. You're a king nonetheless. And America's Constitution in Articles 1 and 2 are a reflection of the American Revolution. So, too, with Article 3. Here's the payoff point. That judges in the colonies generally were not patriot leaders. They were picked by the king in most of the colonies, whereas local legislatures were picked by the citizenry, and governors in many of the states at least were picked by the citizenry. Not in all the states, but in some of them, they were picked by the citizenry. But judges generally in most of the states were picked by the crown. They were loyal to King George. The payoff fact is, at the time of the American Revolution, the chief judges in 10 of the 13 colonies sided with George III, and not George Washington. So judges are not the heroes of the American Revolution. Local militias are. Local juries are playing an important role in resisting parliamentary taxation by sort of acquitting tax smugglers and tax cheats and custom smugglers and the like. So juries are the heroes of the American Revolution. Local assemblies that mobilize the colonists are heroes of the American Revolution. Local militias are seen as very important in this process. Lexington and Concord and Bunker Hill. George Washington is a hero of the Revolution. Judges, not so much. Now, by the time of the Philadelphia Convention in 1787, 11 years after the Declaration of Independence, we've had a regime in which now actually the colonies have become self-governing states, and the king isn't picking the judges. In fact, so Americans are picking their own judges, and so you might think that the time is right for a more robust expression of judicial power, and there is more judicial power in Article 3 than you see in many of the state constitutions. In all the state constitutions that emerged after the Revolution, the judiciary is kind of third out of 3. It's the least powerful branch. It's typically picked by the legislature and doesn't have the same kinds of, in many states, the same kinds of independence that Article 3 will give federal judges. In only one state, Massachusetts, does the Constitution have 3 separate sections of the Constitution for the 3 branches of government, and even then, typically, the judiciary is third and with the least amount of text in that Constitution. So, in the state constitutions, the judiciary tends to be sort of a very weak branch vis-a-vis the legislature. In many of the state constitutions, governors were quite weak. These were state constitutions dominated by the legislative branch. Now, by the time of the Philadelphia Convention, a lot of the Federalists, the supporters of the Constitution, think that these state constitutions are actually bad because they have imbalanced power structures. The legislatures are too powerful, and there's not enough of a check on them. I think of the 39 people who were at Philadelphia, 39 signers of the Constitution at Philadelphia, 6 actually had been prominent state or continental judges. And many of the great lawyers of America were at the Philadelphia Convention, and some of them might have imagined that they might be judges under the new system that was being created. And in fact, of the first 6 Supreme Court justices, half of them are members of the Philadelphia Convention, 3 of the 6, and actually of the 5 more that Washington gets to appoint over the course of his 2 terms. 2 more are from Philadelphia. So the framers of the Constitution are creating a robust judiciary in part because some of them imagine that they will occupy this position. But still, and we're going to see that there are some special protections that are built into Article 3, but let's just, again, emphasize it's third out of 3. Let's think about a few ways in which it's still third out of 3, not just textually, in order and in the amount of text, but kind of structurally. So first of all, there's a kind of democratic logic, or kind of just conceptual logic, to the order. First, actually, the legislature has to pass laws, and then they have to be implemented. That's Article 1. They have to be implemented by an executive branch, and then, if people don't like that, cases come to court. The executive prosecutes some people sue, the executive branch sue government, and things come to court. So legislature first passes a law, Article 1, president executes it, Article 2, court cases arise, Article 3. And that's just kind of a natural order. In 1788, once the Constitution has been ratified, the new government that springs to life is going to materialize in a certain order. First, the Congress has to meet, Article 1. They have to meet first to count the electoral votes, and so only after the electoral votes are counted does the president kind of come on the scene, Article 2, chronologically. And only after both Congress and the president are in place actually, will they be able to pass laws creating actually the judiciary structure? because Article 3, as we're going to see, does not specify how many judges are going to be on the Supreme Court, how many lower federal courts you're going to have. It gives those decisions to Congress. It specifies there will be one Supreme Court, and such inferior courts as Congress may from time to time ordain and establish, but Congress is going to basically shape the structure of the judiciary to an important extent, and so the judiciary chronologically at the founding materializes third. First the Congress comes on the scene, then they count the electoral votes, and then Washington is summoned, he appears, and then once he's there to sign or veto laws, you can have bills emerge structuring the judiciary. The most important early statute is called the Judiciary Act of 1789. It's passed in September of 1789, and it basically sets up the early judiciary and puts it into operation. And this reminds us of a kind of a larger democratic pyramid that you see in the Constitution. The preamble begins, it's the most democratic, it's the base of this sort of great pyramid with exceptional participation by ordinary citizens, we the people, property qualifications lowered or eliminated in 8 of the 13 states. So the Constitution begins with a very broad popular mandate in the preamble. Article 1, very popular branch of government, Congress being created. Article 2, a little bit more removed from the people, the executive branch, with a more indirect means of election through the Electoral College. Article 3 is the apex of the pyramid, but it's the least democratic, it's furthest removed from the people, and the basic structure of the Constitution is more democratic branches should select less democratic, not vice versa. So, for example, judges don't pick other judges. Presidents pick judges. And judges don't pick their chief justice. Actually, politicians do. In the House of Representatives, the politicians pick their own speaker. The Senate picks their own presiding officer, President pro tem or Senate majority leader. So in the legislature, each branch picks its own leaders. But the judges don't pick the chief justice. They don't get to pick that. In the legislature, well, let's take the executive branch. Presidents get to pick cabinet officers, their assistants, but justices don't get to pick lower judges. Each house gets to decide kind of how it's going to operate with rules of its own procedure. But actually, Congress by law can specify many of the procedures of the judiciary, what the rules of evidence are going to be, what the rules of civil and criminal procedure are going to be. Congress even has power to decide how many justices there are going to be, how many lower courts there are going to be. Presidents can fire cabinet officers at will, as we talked about before. Justices can't fire lower court judges at will. So the judiciary has sort of less regulatory power. It to some extent, is under the control of the other more politically accountable branches. So there's this grand democratic pyramid. Preamble first, it's the broadest base. Article 1 second is the next broadest populous base. Article 2 a little bit less broad, and the judiciary on top. And more politically accountable bodies are picking less politically accountable bodies, not vice versa. That's why many of us, that's a structural reason why many of us actually had some real questions about Bush versus Gore, the Supreme Court case, because under the Constitution, presidents are supposed to be picking judges, not judges picking presidents. So you see the thirdness, how the judiciary is the least dangerous branch. That's a phrase from Alexander Hamilton's Federalist number 78, one of a series of newspaper op-eds that the Federalists write in support of the Constitution. You see how the judiciary is in some ways the least dangerous branch. Now, Federalist 78 says that judges are going to have the power to refuse to enforce laws that they deem unconstitutional. We call that judicial review, and I think that is absolutely bedrock in our system. Federalist 78 defends that idea. The Anti-Federalists understood this. Some of them were critical of it, but they understood that judicial review was going to be part of the system. Several state courts had already begun to hold unconstitutional state statutes as violations of state constitutions. So the idea of judicial review was kind of in the air. There was some uncertainty about exactly when and how state judges should do this, how often they had done it. But I think the framers of the Constitution did expect that federal judges would decline to enforce laws that the federal judges thought were unconstitutional, even if the House and the Senate and the President thought that these were perfectly valid laws. Now, remember, that's not a unique power of the judiciary. People in the House of Representatives can vote against the law, and should, that they think is unconstitutional, even if they know the Supreme Court would uphold it. And so too with the Senate. So even today, after the Supreme Court has upheld the Obamacare legislation, it's perfectly permissible for members of the House and Senate to say, we still think it's unconstitutional and we're going to try to repeal it. We're not going to fund it. That's a constitutionally permissible thing for them to do. Now, I happen to think, and we can get into this later perhaps, so that the statute, the Obamacare statute, is not unconstitutional, but our system of government creates multiple checks and balances against an arguably unconstitutional law. The House can vote against it, and if the House votes against it, it doesn't become a law, even if the court would uphold it. And so too with the Senate, and a president can veto it, and he can pardon people who are convicted under statutes that he thinks is unconstitutional. Even after judges have upheld convictions, presidents can pardon people. Thomas Jefferson pardons people convicted under the Sedition Act, even after the Sedition Act of 1798, part of the Alien and Sedition Acts, because Thomas Jefferson thinks that's an unconstitutional statute, even though courts have upheld that statute. So just as the House can basically sometimes be the last word and just say no and make that no stick if the no is we think is unconstitutional, and the Senate and the President, so too with the judiciary. The judiciary has this power to refuse to enforce any law that it deems unconstitutional. To bolster that power, the judiciary is given life tenure, independence from the legislature. Once selected, it's a political selection process. Presidents pick judges, and they can pick them by paying attention to the judge's philosophy. And from the beginning, presidents have attended to likely judicial philosophy of appointees. Washington early on picked only Federalists for the court. And for most of American history, presidents have tended to pick judges that they think support their general vision. And the Senate, too, can confirm judges that they believe have a proper judicial philosophy. So it's a political selection process with the presidency and the Senate. But once the judges are selected, they have life tenure for good behavior in the language of the Constitution. They can't just be sacked as a cabinet officer can if the president decides he doesn't like their opinions. Their salary is undiminishable. It can't go down. It can go up, and that's because since they sit for life, there may be inflation and there may be a need for salary adjustments. But they have, once selected, some independence. And Federalist 78 tells us that one of the most important reasons that they have judicial independence is there is going to be this power of judicial review. They are, on occasion, going to need to invalidate laws or refuse to enforce laws that they, in their own mind, think are unconstitutional. And Hamilton in 78 says when they believe the laws are contrary to the manifest tenor of the Constitution, are kind of clearly unconstitutional, the judges should simply just say no. Now, there is judicial review, but the question is how robust a vision of judicial review did the framers really imagine? Did they imagine judges striking down all sorts of laws all the time, or just occasionally? Do they imagine judges would strike down laws that were only arguably unconstitutional, or instead strike down laws that were clearly and undeniably unconstitutional? Did they imagine that judges would strike down mainly laws regulating the judiciary itself, or all sorts of other statutes? So there is judicial review in the Constitution, but what kind of judicial review? How do juries fit into the whole equation? These are some of the questions we're going to talk about in our next lecture, and we'll come back to this picture of John Marshall, so stay tuned. Welcome back. We're in the middle of a discussion of Article 3 of the Constitution, the judiciary article, and we've been talking about something that modern people refer to as judicial review, the power and indeed the duty of judges to refuse to enforce laws that they, in their independent judgment, deem unconstitutional, even though those laws have been passed by the House of Representatives and the Senate, signed by a president, or passed over a president's veto. Even though these laws have been duly enacted in a procedural sense, judges have the power and indeed the duty to refuse to enforce those laws if they deem them unconstitutional. We call that judicial review. It's not something that's explicitly in the Constitution in so many words, but I think it's a deep part of the Constitution's overall text read holistically and structure. The argument is not that because there's a thing called the Supreme Court and the Constitution is supreme law, that judges on the Supreme Court have some unique power. The justices on the Supreme Court are generally supreme over the other judges. There's a kind of a judicial pyramid. Supreme Court justices can overturn courts of appeals, and below them, trial courts. But the Supreme Court is not really supreme over the other branches, just over the other courts. And this power of holding something unconstitutional, of refusing to give effect for something that you think is unconstitutional, is not limited to the Supreme Court. It's true of all other federal judges. It's true of state judges. We're going to see to some extent at the founding, people thought it was true of jurors. The power to refuse to give effect to something that you deem unconstitutional is a power, as we've seen, shared in some ways by other branches of government as well. The House can just say no and refuse to vote for a law it thinks is unconstitutional, even if it knows the courts would uphold it or have upheld a very similar law. So too with the Senate. Presidents can veto laws that they believe are unconstitutional. Call that even if courts would uphold those laws or have upheld them. Think of Andrew Jackson refusing to sign a new bank bill even after John Marshall's Supreme Court had upheld the constitutionality of a federal bank in McCullough versus Maryland. Presidents can even refuse to enforce certain bills that they think are unconstitutional, at least until a court case materializes. There's a kind of executive review in the Constitution alongside judicial review. And remember, presidents are made independent of the legislature too. They're not picked ordinarily just by the legislature. They're picked through an independent electoral college system. They have undiminishable salary, and indeed their salary can't be increased either. Judges can be increased, so they're vulnerable to possible congressional bribery, but presidential salaries within a 4-year term can be neither increased nor decreased. They've got a term of office independent of the legislature, 4 years rather than for life. But there's a thing called executive review, really, alongside judicial review. Remember that Thomas Jefferson is going to pardon everyone that has been convicted under a Sedition Act, even after Supreme Court justices riding circuit have upheld the Sedition Act against constitutional challenge. So the basic argument for what we call judicial review is not necessarily something unique about the judiciary. It simply follows from two basic facts. One, the Constitution is the supreme law of the land. It trumps an ordinary statute, whether a congressional statute or a state statute. Why is it the supreme law of the land? Because it comes more authentically from the people. It's a more democratic law than a law passed by an ordinary Congress. So the Constitution and its amendments come more directly from the people. Amendments are much more difficult to adopt than ordinary statutes. And so because an amendment was hard to adopt, it should be hard to change. An ordinary statute should not suffice to, in effect, undo an amendment that required 2/3 of the House, 2/3 of the Senate, 3/4 of the states. A much broader process generated the Constitution itself and its amendments, and so ordinary statutes actually rank lower in their democratic pedigree. The Constitution is the supreme law of the land. That's the first step. And the second step is, and judges enforce law. Judges are supposed to follow law, and if the Constitution is inconsistent with the statute, they're supposed to follow the Constitution in the same way that if a valid federal law is inconsistent with a state statute, they're supposed to follow the valid federal law because the Supremacy Clause actually of the Constitution, which we'll talk about in later lectures, it's in Article 6, says the Constitution is the supreme law, and then congressional statutes, but only ones that are consistent with the Constitution in pursuance of the Constitution. And then below that, state constitutions and state statutes and so on. And that's the democratic hierarchy of law. And judicial review is basically just a recognition of the supremacy of the Constitution as the supreme law of the land and the fact that judges are supposed to enforce law. Now, that's the basic argument of the Federalist Number 78 in support of what we call judicial review. It's a basic argument that you see in an opinion by John Marshall in 1803 for the court called Marbury versus Madison. But exactly how robust a conception of judicial review did the framers envision? I suggest at the founding it was rather modest. Here are a few reasons for thinking so. First, remember that the Constitution doesn't specify the size of the Supreme Court. Now, if the Supreme Court was going to be invalidating acts of Congress right and left, if it was going to be as important as, say, as the president in the veto process or something, you'd think that the framers would have specified much more how many justices there would be. In the same way that there was a lot of wrangling about apportionment of the House of Representatives, apportionment of the Senate, how the Electoral College was to be structured. If the Supreme Court was basically an organ of national power that was designed to make sure that the states complied with the Constitution, then you could imagine that the framers actually were going to leave to Congress a lot of power over the size and shape of the court. So in the same way that Congress would decide how to structure a post office, how to structure the Treasury Department, Congress could structure the judiciary as an organ of national power to monitor the states. And by the way, that idea of monitoring, of the judiciary monitoring the states is an idea that went back to the colonial era. When colonists passed laws in their assemblies, judges in the Privy Council could, judges and other officials of the central government could invalidate colonial laws. And the framers of the Constitution thought that the state legislatures actually sort of needed a little bit of checking and monitoring, a little bit of oversight from the new central government that they were trying to create. They were trying to create, in effect, a little bit of a substitute for the review of colonial statutes embodied in the Privy Council. And indeed, early on, John Marshall's court strikes down lots and lots of state laws. He's siding with the federal government, he and his Supreme Court, John Marshall, invalidating state laws as violative of federal statutes and the federal Constitution. So lots of invalidations of state laws. Basically, on Marshall's watch, only one invalidation of a congressional statute. That's in Marbury versus Madison. I think that's consistent with the idea that the Supreme Court's size isn't specified. Now, by the way, precisely because its size isn't specified, its apportionment rules, it's going to be vulnerable eventually to a pro-slavery tilt. Because of the 3/5 clause, the Congress tilts toward the South. Because of the 3/5 clause, the presidency tilts towards the South. Pro-slavery presidents like Andrew Jackson eventually become sort of dominant, and they can appoint pro-slavery judges, and they can sign into law pro-slavery apportionment rules. By the time of the Dred Scott case in the 1850s, the Supreme Court is apportioned so that even though the slaveholding South has less than a third of America's free population, it has it has a majority on the Supreme Court. So it's kind of malapportioned, and that's going to create some problems. That when that malapportioned court gives us the Dred Scott case. The original Supreme Court had 6 members, an even number. How odd. Because you see, if it's supposed to be deciding all the important constitutional issues, you'd imagine that you'd want an odd number so that 4 could beat 3 or 5 could trump 4. But originally, it's 6. That's another sign that they're not imagining, the framers are, the Supreme Court as the kind of massive force it's become in American history. Here's another little clue. When presidents veto bills, they are supposed to actually give a written statement of reasons for vetoing the bill, send a message back to Congress, and the Constitution prescribes all of that, and many of the early veto messages are, in fact, based on constitutional objections, as we talked about in earlier lectures. About half of the early vetoes, roughly 24 out of 50, say, in the antebellum, the pre-Civil War period, roughly half of them are constitutional vetoes. And the Constitution is imagining, the framers were imagining, the veto as an important mechanism of constitutional oversight, a check and balance of the legislature. But judicial opinions, not so much. There's nothing in the written Constitution that says that judicial opinions even have to be written, and the way that the veto message is. There's nothing that says there has to be an opinion of the court. And indeed, before John Marshall comes along, there isn't actually an opinion of the court as such. Individual justices kind of give their opinions from the bench randomly, and sometimes there's someone to write it down. Not always. Their opinions are not collective. They're not immediately published. John Marshall is going to change all of that. But that's yet another signal that that the framers did not quite imagine judicial review to be as robust as it becomes. In all of Marshall's time on the court, he strikes down one federal statute. It's in a case called Marbury versus Madsen. He strikes down lots of state statutes, but only one federal statute. And that federal statute is regulating the judiciary itself. The flaw in the statute, as Marshall saw it, was that the statute improperly expanded the original jurisdiction of the Supreme Court, giving them cases to hear at trial that they should instead have been hearing on appeal. So a very technical issue involving the judiciary itself. That's the only time before 1850 that the Supreme Court invalidates an act of Congress, even though it's invalidating lots and lots of state laws, as I said, and even though presidents are vetoing all sorts of bills on constitutional grounds, and they're vetoing bills that courts have upheld or would uphold. See, for example, Jackson's veto of the bank. Presidents are pardoning people that courts have actually said don't have a good defense. See Thomas Jefferson's pardon of people who were accused of violating the Sedition Act. So if all of that is so, if the judiciary originally is sort of more a branch of the central government monitoring states, making sure that states comply with the Constitution and with valid federal laws. By the way, that's McCulloch versus Maryland. Upholding a congressional scheme and invalidating a federal bank, a state effort to tax that bank and undo it. So that's paradigmatic of the Marshall Court. John Marshall, a former congressperson himself, siding with Congress against the states, and in so doing, kind of carrying forward a theme from the colonial experience of members of the central government monitoring local compliance with empire-wide, continent-wide rules. So if that's early-style judicial review with only one important invalidation of an act of Congress by the Supreme Court, and that an act involving the judiciary itself, how is it And by the way, state courts in the early revolutionary period had exercised judicial review by invalidating state statutes, which are seen as violating state constitutions. But most of those early examples of state-style judicial review involved judiciary specific laws about juries, for example. So how is it then, you might ask, that this founding judiciary, the least dangerous branch, third out of three, pretty modest, doesn't get to pick its own subordinates. Supreme Court justices can't pick lower court judges, doesn't get to pick its own leaders. Justices can't pick the Chief Justice, doesn't get to have an absolute right to regulate its own procedures or evidence. Its shape can be manipulated by Congress. Congress can add to it or subtract from the size of the justices if they don't like the rulings of the current justices. If all of that is so, how is it that the judiciary has become much more powerful over time? Supreme in some sense, arguably, even over other branches, or at least some Supreme Court justices think that, and ordinary people think that there's a unique power and duty of courts, and among them the Supreme Court, and court judges more than juries, to say what the law is and enforce the Constitution. Well, I think a few factors are at play, and let's just talk about them, and they're post-founding factors. One, a lot more judges today. At the founding, there are only 15 lower court judges, and there soon become 105 or so members of the House of Representatives. 7 congresspeople for 7 representatives for every judge. Today, there are about 2 federal judges for every member of the House of Representatives. That's a 15-fold increase in the ratio of judges to members of Congress. Today, young lawyers are much more likely to start their careers clerking for a judge than interning for a member of Congress. So one thing, the judiciary has become powerful just because there are a lot more of them. You know, the old joke, friends come and go, but enemies accumulate. Well, judges accumulate. And the Supreme Court sits atop this ever-increasing pyramid. When we have more laws, more complex laws, we need more judges to implement them. A huge judicial pyramid with radiating power in various districts. You may be more likely to know a federal judge than your own member of the House of Representatives. Congress can't expand infinitely. Congress has about 500 people now, 435 in the House. If it were 4,000, it would be even more dysfunctional than at 400. And if it were 40,000, all the more. Judges, you can keep expanding that pyramid. So that's one thing that happened. Second thing that happened is judges got control over their docket, a thing called certiorari. The justices could decide which cases they were going to hear, and that gives them the power, in effect, to define a kind of legislative agenda. In the early period, almost all the important issues actually are resolved outside the judiciary. Can presidents fire cabinet officers at will? Can the federal government assume state war debts? Is a bank of the United States constitutional? That doesn't reach the Supreme Court until 30 years after the founding debates about all of this. Can presidents negotiate treaties secretly? Can they issue neutrality proclamations? Is the Sedition Act unconstitutional? Issue after issue after issue, the big ones don't come before the Supreme Court. On the Sedition Act, for example, the Supreme Court doesn't have, as such, appellate jurisdiction over all federal criminal cases. And it only gets that late in the 19th century. Justices are riding circuit and deciding cases individually, but not quite as a Supreme Court. So, more judges, that's one answer. Second, they get to hear more cases. These restrictions on their jurisdiction are gradually fall away. The Supreme Court has more control over its docket. It now sits atop a huge pyramid of federal judges who can be seen as just so many lieutenants enforcing Supreme Court mandates. We have a series of amendments that are designed with judicial review in mind to create judicially enforceable rights, especially after the Civil War, rights against states and the federal government, and the courts are very vigilant in enforcing rights against states, as we've seen. That's going to be the story of the Reconstruction Amendments. We have the emergence of divided government in the 20th century. So when the Congress is controlled by a different party than the president, they're at loggerheads, and so courts can do lots more stuff, and no matter what they do, they're not going to get invalidated because either the president will like it or the Congress will like it, and either the president or the Congress can stop any law that would try to retaliate against the justices or overturn their controversial decision. So in a world of unified government, where the House, the Senate, the presidency are all dominated by the same party, judges have less ability to sort of smack down political actions because they can in turn be retaliated against by a unified House, Senate, presidency. But in the modern era, we don't have that so much. We have post-Watergate and Vietnam, a sense that our political branches have lied to us. And the courts actually have been part of the solution, the Nixon tapes case, the Pentagon Papers case. So presidents are seen now as partisan officials, and that wasn't true of George Washington, whereas justices have positioned themselves as sort of more above party. Whether that's true or not, that's actually the persona. So a whole bunch of reasons, I think, why judges today are much more powerful than before, and many, many more acts of judicial review. In the modern era, the Supreme Court about twice a year is invalidating, 3 times a year is invalidating an act of Congress. In the entire period before 1850, there was 1 invalidation of an act of Congress. That's called Marbury versus Madison. It was a judiciary-specific law. So today, as I said, in the modern era, the court every year is as robust against Congress or more than in the entire period before 1850. So we've talked a bit about judges. Let me tell you a couple more things about Article 3. It gives judges power to hear all federal cases, and it's not at all clear that Congress can take that power away from federal courts. It might be able to reallocate, give power to one federal court or another court, but Congress is limited in its ability to take away all federal cases of a certain sort from the federal judiciary. So said John Marshall's court in an important case called Martin versus Hunter's lessee. Let me just say a word or two about juries, and then I'm going to come back to the picture of John Marshall. I've been talking about judges a lot because today judges are the main event. When we say Article 3, we think judges. But for the framers, juries were a lower house of a bicameral judiciary. They were an important part of the process. They are mentioned in Article 3. Criminal cases have to be tried to a jury under Article 3. The Anti-Federalists said, that's not enough. We want more protections for juries. What about civil juries? You're not specifying that the jury, for example, has to come from a certain district or vicinage. We need more protections for juries than you are recognizing. Even Marbury versus Madison, by the way, can be thought of as involving jury rights. Why would you not want the original jurisdiction of the Supreme Court to be expanded? Because the Supreme Court's going to be sitting in Washington, D.C., and if it gets to hear a case, then a local jury isn't participating. But if instead the Supreme Court doesn't hear the case and some other lower federal court hears it in the hinterlands, there's going to be a local jury involved. So the whole debate about the Bill of Rights in the ratification process, when critics say, hey, you forgot the rights, is precipitated in part by a criticism of Article 3, saying, you know, it mentions juries, but not robustly enough. Not civil juries, not enough protection for juries. It mentions criminal procedure. It says in impeachment, for treason, it says that things have to happen in open court and there have to be 2 witnesses to a treason. But what about all the other rights of criminal defendants? What about rights of counsel and against double jeopardy and the right not to be compelled to incriminate yourself and so on? It says treason will consist only of levying war against the United States. It's kind of a protection, therefore, of free speech. You can't be prosecuted for treason merely for criticizing the government. But you didn't say so that explicitly. Why isn't there more explicit protection of free speech and free expression? So this treason clause, which can be seen as a kind of proto-Bill of Rights, the jury provisions of Article 3, which can be seen of as a seed crystal of the Bill of Rights, precipitate a conversation saying, you know, we need a lot more rights. And that's going to lead to a Bill of Rights. So Article 3 is in some ways a gateway to the early amendments. Now, before I conclude, I just wanted to come back, because I promised I would, to this picture that begins Chapter 6 of America's Constitution, a biography. Every chapter begins with a picture, and if you understand the picture, you understand the lecture. This is John Marshall. He's the great early Chief Justice, and before he comes along, the Supreme Court actually is practically impotent. And he makes it the Supreme Court. After Marshall, the justices are going to speak actually with an opinion of the court, which the Constitution doesn't require. And they're going to issue written opinions, which the Constitution doesn't require. So his kind of counterpart to the president's veto message. And he is going to invalidate all sorts of state laws that are inconsistent with the federal scheme, but he's not going to pick too many fights with Congress because he's going to lose that. His branch isn't as powerful. It is the least dangerous to begin with. He's himself a former congressperson, a former diplomat, very popular, and he helps establish judicial review in Marbury versus Madison, but he doesn't push it too far. In general, his court is going to be upholding federal exercises of power, like the federal bank, and invalidating state laws that interfere with that. He's going to give us the idea of a modern Supreme Court. He's going to stick around for a very long time, showing that life tenure, this good behavior, means something. Before him, Chief Justices left early. They didn't have to, but they chose to leave early. So just as Washington establishes a tradition that the presidency, although he can be reelected again and again, presidency should end after 2 terms, so a kind of a gloss on Article 2. Marshall establishes a gloss on Article 3. Now, life tenure means that judges shouldn't leave early. They should stick around to the end. So in earlier lectures, I said, well, if you understand George Washington, you see a lot about the early presidency. If you understand Andrew Jackson, you see what the presidency became. If you see Henry Clay, you see Congress as a great a speechifying body. So three big themes about the Constitution have emerged early on. And if you see John Marshall, he embodies the power of the early of the Supreme Court that he helps actualize. It's not as clear in the text, but he makes it real. What are the 3 big themes of our story so far? The Constitution is more democratic than we've been told, more pro-slavery than we've been told, and more about national security. Who's John Marshall? He's a very, before he was on the Supreme Court, he's a very popular politician, a man of the people, probably the most popular member of his party, the Federalist Party, in America, especially after Hamilton's death. So a former politician becoming a judge. So you see sort of writing for ordinary people, writing opinions that ordinary people can understand. So a master practitioner of a kind of democratic politics. He's from Virginia, a slaveholding regime, but he's a critic of slavery. And we're going to come back to that in a minute. He doesn't think that slavery is this great thing. And that way he's like Washington, like Thomas Jefferson, who's his cousin, by the way. He's also one of America's leading diplomats. He understands national security. He comes to national prominence in part as a diplomat in France. And he is a hero of the American Revolution. He's there with George Washington. He's there at Valley Forge. He writes famous opinions upholding national security powers of the federal government and national bank. So democracy, slavery, national security, all embodied in the person of John Marshall. Now, just as George Washington, who is a slaveholder but who frees his slaves and thinks slavery is basically going to be the death of the Republic, is ultimately succeeded by Andrew Jackson, who is much more pro-slavery. In fact, at least as a constitutional matter, and will support the slave power. So John Marshall is going to be succeeded by Roger Taney, whose constitutional vision is much more pro-slavery. Who puts Taney on the court? Andrew Jackson. How does Andrew Jackson become president? The 3/5 clause. So Marshall is a Virginian who is a critic of slavery. He doesn't want this to be a slaveholding republic forever. He is succeeded, though, by Taney, whose constitutional vision is much more enthusiastically pro-slavery, a Jackson appointee. And because of that, the Dred Scott case, a man named Lincoln will arise and say, the Constitution is skewing far too much in a pro-slavery direction. We have to stop this. And the confrontation between Lincoln's vision and Taney's vision will eventually culminate in the Civil War, and the Constitution will be transformed in the process. But that's basically the story for later lectures. I promise I'll tell that story to you, so stay tuned.
Hi, I'm Danny, one of the TAs from Professor Amar's Constitutional Law class. This week for our interactive segment, I'll be going over some of the questions that are on the discussion forums, not only from our live question and answer session a couple weeks ago, but also from the questions about the individual week's lecture materials that you are posting online. I know I'm speaking for all the TAs when I say we're really appreciating all of the questions you guys have been asking, and also all of the deep and specific conversations that have been going on in the discussion forums. We are really impressed by the level of conversations that are going on, and there are a lot of really interesting questions out there. So, having said that, let's move on to the first question. That's one from James Raths, who asks, where in the Constitution does it say how the size of the House of Representatives can be changed? Why isn't the House still limited to 65 members? And with that, he's alluding to the size of the House at the time of the ratification of the Constitution. So, the size of the House of Representatives is a little bit different than the size of the Senate. Article 1, Section 2 of the Constitution specifies that in Clause 3, that representatives for the House of Representatives shall be apportioned among the several states according to their respective numbers. This is unlike Article 1, Section 3, which gives a very concrete rule that the Senate of the United States shall be composed of 2 senators from each state. So what you see here is that in Article 1, the size of the House of Representatives is going to be changing over time according to how Congress itself decides it should be apportioned. That means it's done not by constitutional amendment or within the first and original text of the Constitution, but rather by statutes that Congress passes every so often to determine how many representatives there will be and how they'll be apportioned among the several states. Now, the Constitution doesn't say any number is okay. It puts both a floor and a ceiling on the number of members of the House of Representatives. So, as a floor, Article 1, Section 2, Clause 3 specifies that each state shall have at least 1 representative. So, as of today, there'd have to be at least 50 representatives, although it's a little bit odd to conceive of a House of Representatives that is smaller than the Senate. There's no firm constitutional rule that says the House of Representatives must be larger than the Senate, but there are some clues, both historical and textual, that indicate that it was designed to be the larger of the 2 houses. For instance, Article 1, Section 2 in the first clause says that in order to vote for members of the House of Representatives, electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. That basically means that structurally, the House of Representatives is designed to be analogous to the more democratically elected, more numerous House of the state legislatures too. So the floor then is set at 1 representative per state, although there's a suggestion that it should always be bigger than the Senate. Then there's a ceiling, too, saying that the number of representatives shall not exceed 1 for every 30,000 people in the United States. This, though, is a pretty big range. You can see that by just looking at the size of the United States today, 50 states around 300 million people, and that would mean that the size of the House of Representatives could range from 50 representatives to around 10,000 representatives, which is a pretty big margin. And actually, at the time of the founding, a lot of people were concerned with exactly James's question about how Congress would apportion the number of people in the House of Representatives and what the number would be. Would it be more like 65, or would it be more like thousands of people? As Professor Amar himself actually wrote on page 78 of America's Constitutional Biography, no aspect of the federal Constitution provoked more trenchant criticism than the House size. There were a number of debates that Anti-Federalists had where they were concerned about the small size of the House of Representatives. They were concerned that a smaller House would be more susceptible to bribery and corruption because it would be easier to buy the votes of a smaller number of people than it would be to buy the votes of a larger number of people. They were also just democratically concerned that there wouldn't be enough opportunity for political involvement of people who wanted to run for office if there were fewer offices to have. And there's also a concern, just in terms of representational democracy, that any one representative who has to represent the interests of more and more people would be less able to represent them well. And one of the ways you can see historically just the depth to which this debate happened is that it wasn't even resolved until the very last day of the Constitutional Convention, at which point George Washington himself intervened. This is pretty remarkable because George Washington had been making a habit of not intervening in substantive debates during the Constitutional Convention, which he presided over, but rather remaining neutral on most of the issues. However, when it came to the size of the House of Representatives, George Washington suggested a change in the maximum number of representatives allowed in order to make the House potentially bigger. So on the very last day, they changed the maximum rule from 1 for every 40,000 people to 1 for every 30,000 people. Now, especially at the time of the founding, when the population of the United States was much smaller, this could actually be a considerable change in the number of representatives allowed. What's also remarkable about this change that George Washington suggested on the very last day is that if you look at the U.S. Constitution itself in the National Archives, you can still see the smudge on the document from where the change was made from 40,000 to 30,000. Even with this change, though, people still had concerns. And during ratification debates, all of these concerns about corruption and political participation still raged. And 5 states, when they ratified the Constitution, specified with appended documents to their ratification vote that they believed the House of Representatives should be larger than just 65, as it was established originally in the Constitution. So by 1793, Congress had responded to these requests or demands, depending on how you characterize them, and increased the House size to around 100. And the House of Representatives kept increasing with the population of the United States throughout the 19th and 20th centuries and until around 1912, when it capped out at 435, which is the size that it's remained to this day. So thanks, James, for that question. Next up, we've got a question from Norm, who asks, why did the Supreme Court not rule the Alien and Sedition Acts unconstitutional immediately, referring to a set of acts passed in the late 18th century, right around the first Congresses that criminalized certain things that we would think would be unconstitutional to criminalize today, such as criticism of the government. Now, this is a question that has a lot of layers, and one of the first important things to be clear about is that the Supreme Court, under our Constitution's structure, does not issue what are sometimes called advisory opinions, where a court can simply take it upon itself to declare certain things about the law or certain things about the world without parties in front of it. That's because under Article 3 of the Constitution, the Supreme Court is only allowed to rule on cases and controversies that are brought before it. So, simply put, even if a law may be unconstitutional, the Supreme Court won't declare it that way until parties bring the case before the court. Now, the Alien and Sedition Acts were not actually tested in front of the Supreme Court, although there were numerous other courts that did convict people, and there were successful cases brought under the Sedition Acts. The other thing to think about in terms of judicial review, which is courts declaring acts of Congress unconstitutional, is that it was not as firmly established at the end of the 18th century or beginning of the 19th century as it was today. Today we take it as more of a given that the Supreme Court can hold laws unconstitutional, but around the time of the founding, that was on shakier ground. Finally, there's the fact that even if the Supreme Court were to directly consider the constitutionality of the Alien and Sedition Acts at the time that they were passed, the First Amendment was not regularly used to strike down laws that Congress passed until into the 20th century. So even though we today think of the First Amendment as a very powerful tool for courts to use, it took quite some time for it to get that way. One of the interesting things that you can see with the history of the Alien and Sedition Acts, though, is the role of other branches beyond the Supreme Court in interpretation of what is and is not constitutional. So, for instance, Thomas Jefferson was a vehement critic of the Alien and Sedition Acts, and when he was elected in 1800, he pardoned people who had been prosecuted underneath it, and he also reimbursed them for the fines that they had been charged under the Alien and Sedition Acts. He also, as all presidents do, had the non-prosecutorial power, which is a fancy way of saying a president can decide not to prosecute someone under a criminal law. So if Congress passes a law criminalizing certain behavior, and the president views that criminalization as unconstitutional, the president doesn't need for the Supreme Court to weigh in on the matter because the president can decide not to bring any charges against people for violating that law. Jefferson did this with the Alien and Sedition Acts. And ultimately, one of the things that the Alien and Sedition Acts also reinforces is the role of the people like you and me, in constitutional interpretation through the voting box. In the election of 1800, the constitutionality of the Alien and Sedition Acts was a major issue, and Jefferson wrote and spoke about it regularly. It was on people's minds. And, in the election of 1800, we got a new president and a new Congress, and ultimately the Alien and Sedition Acts expired, and the new Congress did not make new ones, and the new president probably would not have signed a new one. So that's one of the ways you can see in which, even if the Supreme Court doesn't hold an act unconstitutional, Congress, the president, and ultimately the voters can decide that certain things are outside of what we want in our constitutional order. So that was a great question, too. Finally, we've got a question on secret voting that is appropriately from an anonymous commenter. Anonymous asks, was there ever any consideration of making all individual congressional votes secret? Congressmen, under a secret voting campaign, would vote with their hearts rather than along strict party lines. And what's interesting to see about this is that there's actually no constitutional requirement for public voting. There's nothing in the Constitution that mandates that votes in the House or the Senate not be secret. And so it's not just a question of whether there was a historical consideration of whether we can make all individual congressional votes secret, but rather a question that exists to this day. Article 1, Section 5 of the Constitution specifies that each House may determine the rules of its proceedings. In general, the House and the Senate are allowed to determine the rules by which they bring things up for vote, deliberate on them, and vote on them. Now, there is a specific provision related to secrecy of ballots, which is that in Article 1, Section 5, Clause 3, the yeas and nays of the members of each House on any question shall, at the desire of 1/5 of those present, be entered on the journal. And in the same clause, the Constitution specifies that each House shall keep this journal and shall publish it from time to time. So what this means is basically if 1/5 of the present members of the House of Representatives decide that they want a vote to be made public, the Constitution specifies that it must be so. This isn't to say, though, that all of the other votes must be public or must be private. And like many things in the Constitution, it's not specified firmly, but rather given up to the discretion of the representatives in Congress, and therefore ultimately of the people. So Anonymous suggests that maybe there are reasons we think that secret votes in Congress would be a good thing. And that's a conversation that I encourage you to join on the discussion forums. But the important thing to see is that if it is a good thing, the person to talk to is your congressman. We don't need a constitutional amendment. We would just need the House itself to change the rules of its proceedings and allow secret votes more often. Thank you, and we look forward to more of these great questions over the coming weeks.